Welcome to Family Law War Room with Brad LaMorgese.
Hello, everyone, and welcome back to Family Law War Room with Brad LaMorgese. Brad's a board-certified family law attorney in Texas who specializes in high-stakes divorce, complex property division, jurisdiction disputes, and family law appeals. I'm Sean O'Connor, and today Brad and I are talking about divorce for business owners and executives in Texas and what's truly at risk when personal litigation intersects with your professional life. Hello, Brad. How are you?
Pretty good. How about you, Sean?
I'm doing pretty well. I know we've talked around this issue in terms of complex cases and business ownership and those various things that complicate a divorce. Why do divorce cases involving executives, entrepreneurs, business owners, and the like, often become more strategically complicated than other family law matters?
I think it's interesting because they become more complicated because it's not necessarily always just about dividing assets anymore. It's about managing risk across multiple dimensions at the same time. So you're dealing with an executive or a business owner, their income, ownership interests, and often their reputation all
Hmm.
tied together. The decisions made in the divorce case can not only affect their personal finances, but business operations, leadership roles, and long term stability. There's also a level of complexity on how wealth is structured. It's rarely just salaries and savings, it's equity, deferred compensation, partnership interests, things that don't fit neatly into a standard division analysis or in things that necessarily aren't liquid. And then there's decision
Yeah.
making pressure, every move in the case, what to disclose, when to settle, how aggressive to be has potential ripple effects beyond the courtroom. So the complexity comes from the fact that you're not just resolving a family law issue, you're managing interconnected personal and in a professional system under stress.
Yeah, I'm also thinking about and maybe we'll touch on this later, but just in terms of if the company or the executive are high profile, right? In terms of public figures and that sort of thing, right? That's got to be another uh, issue to kind of manage. Things get out there in the press, so to speak.
Yeah, it's interesting because some high profile figures love the spotlight and are very comfortable airing things out. And then many are not. Many would rather, and it's most people would rather get their private disputes not resolved in public. So, it just depends.
What about financial pressures? What do you see? What tends to emerge when someone's income, ownership interests or long-term compensation are tied closely to a business?
Yeah, one of the biggest pressures is the disconnect between income on paper and then actual liquidity. An executive or business
Hmm.
owner may have substantial wealth tied up in equity or retained earnings or future compensation, but may not have access to cash in a way that makes it easy to divide or use for a settlement. So you end up with competing pressures. On one hand, the need to value and divide those interests, and on the other side, the practical reality of extracting value from a business that could disrupt operations or even hamper long-term growth. And then there's also volatility, like particularly in Texas, the oil and gas world has been so volatile and income may fluctuate based on performance, market conditions, business decisions that makes it difficult to establish. And in the oil and gas entities, for instance, you may get a very large value right now that's not really the actual value. So you're looking at a blended factor over time, or maybe we're in some permanent, increases of value or decreases of value. So financial pressure is not just about how much, it's about how and when value can actually be realized.
Yeah, that's interesting. I mean, there's in part crystal balling things, right? To maybe it's okay, we're gonna you look at the stock price, so to speak, over the course of the last couple of years, and you use that to predict we're likely to do this, and then you can buy someone out. But I can also see like, well, no, you need to sell your shares in this company in order to pay me out of the divorce, but maybe markets aren't favorable to selling, right? Like we'll take a bath. What if, I'm imagining, hey, can we agree to divide this when it hits X? I mean, I'm imagining that. Do you ever see that kind of a
Yeah, there's big risk either way to taking cash, not taking cash, or or for instance, stock options. They may not look like they're very valuable, but they can really go through the roof. And then you might regret not taking a stock option that may not have liquidity, but ultimately have a lot of liquidity later. So
interesting? Are there other ways, we're talking about the compensation structures, the bonuses, the stock options, equity awards, all these sort of very contemporary ways in which executives are compensated these days. Um, are there other ways, other factors that come into play and why these things are especially, complicating factors in a divorce?
I think so because the compensation structures typically blur the line between present value and future potential, like we're talking. So you're dealing with
Mhm.
benefits that could vest over time. They may depend on performance. They may be subject to conditions that aren't fully satisfied. And so the question becomes, what portion of the compensation is attributable to the marriage? And then how are we going to divide it? Are we going to take those shares of stock? Are we going to value them at a cash out value? Deferred comp can also be tied to future benchmarks. And so you may have claims that some portion is separate property. If it's, for instance, athletes, there's famous cases in Texas where even though there's a guaranteed contract, future performance can make that asset separate property because it's tied to working after a divorce. So you may not have a fixed value and you're working with, as we talked about earlier, projections, assumptions, and contingencies.
Mhm. I get it. Yeah. Um, it's interesting. I mean, it's fascinating, the amount of detail that comes into play for sure. I'm wondering about uh, businesses, like privately owned companies, right? I'm like, what concerns arise when the success or, stability of a privately owned company gets all tangled up with the divorce itself?
Well, and that's where stakes become particularly high because if the
Mhm.
business is closely tied to one spouse's involvement, whether that's leadership, decision making, or revenue generation, then the divorce can directly affect how the business operates. There could be concerns about distraction, changes in decision making, or even internal instability if key personnel become aware of the situation. You have external concerns, lenders, investors, and business partners may react to uncertainty, especially if the divorce introduces questions of ownership, control, or financial obligations. From a legal perspective,
Mm.
you have to balance the need for disclosures and documents and in your diligence with the need to protect the business. And overly aggressive litigation
Right.
can often harm the very asset you're trying to value and divide. So the focus is not just on division, but also on preservation and how to resolve the case without undermining the business itself.
It's like, I think exit strategy as a term, you know what I mean? We're getting divorced, but you need the, especially with a business. I'm thinking about like in a, privately held or family business where, oh, my brother-in-law and my cousins or my father, like there's literally different factions and, you know, perhaps are going to be less happy about a divorce happening. And then, hey, keep your eye on the ball. We're launching a new product, you know?
Yeah, there's a need to be smart, but that can be challenging in divorce cases where, as we've said, emotions run high, and so somebody may have an incentive. Well, I want to destroy the business, which is usually a terrible idea for everybody.
Yeah. I get that for sure. What about things like privacy, confidentiality, reputation, right? Reputational concerns become especially significant for executives or high profile professionals, like we were talking about earlier, right? Some are used to being in the spotlight. Some would really rather not be airing their dirty laundry, so to speak.
In most of those cases, we're going to have a confidentiality order. We may even seal the file. So privacy and
Mm.
confidentiality become critical almost immediately, and particularly the high profile cases, but also a case where there's really sensitive financial or business information, compensation structures, business strategy,
Oh,
you know,
pretty proprietary
proprietary
stuff for the
stuff that
business.
could be
Yeah.
exposed during the litigation. The reputational component you mentioned is, even if the underlying issues are private, the existence of a dispute is obviously going to become known, and particularly if it involves public filings or business related parties getting drug into that litigation, that's not good. So
Mhm.
part of the strategy is managing what, not only what's disclosed, how it's disclosed, but how to eliminate unnecessary exposure. This can include, like I
Mhm.
said, confidentiality orders, protective orders, certainly careful handling of discovery, and then strategic decisions about how a case is litigated. Because once information's out, like the secret to Coke or whatever, it's very difficult to control where it goes or how it's interpreted.
Yeah, and would you say Texas is fairly, I'll say friendly, in terms of I don't even have a comparison because I'm just a layman in this stuff, but, in terms of the court's willingness to sort of keep things out of I mean, certain the law's the law and certain information is just public, if it's going to court. But I'm curious if Texas is a particularly like, no, actually, they're pretty open to keeping it on the down low within the law, of course.
I think Texas is it is a business friendly state, no question. We have our motto, Texas is open for business. And so I think most often you'll see the judges very protective. You'll see confidentiality orders entered. We do have a balance of the open courts doctrine, so people can come to court and observe proceedings. So that makes it a little bit more challenging, but there's even mechanisms within that. If it's a very high profile case, the press, as always, is prying and trying to figure out what's going on, what's being filed, and they love to publish it. So that makes it more challenging. But I would say overall, Texas is pretty protective of people's private information.
Just curious. Are there kinds of financial practices or informal business arrangements that tend to create avoidable problems once a divorce case moves into discovery? Because I'm thinking a lot of times, you start a business with your best friend, or, certain things just decisions are made on the fly, maybe not properly codified, that kind of a thing. What have you seen that maybe could be avoided?
All the time. So I would say discovery is a good way of exposing practices that can seem routine to people but don't hold up well under scrutiny. One common issue, for instance, would be a lack of separation between personal and business expense.
Mm.
And if those lines are blurred, it's harder to create a clean financial picture. And so that can affect the valuation of a business for sure, that it should be valued at a higher rate. The other issue would be, as you pointed out, kind of informal record keeping decisions or decisions that were made without documentation, arrangements not clearly recorded.
Hmm.
A particular problem is if compensation structures are not consistently defined or applied.
Oh,
So
yeah.
you're having one party saying, well, look, this is what they're going to get. And the other one saying, well, I don't get that. But you have it in writing. And so that can create conflict. And none of those issues necessarily indicate wrongdoing, but they create complexity and open the door for disputes about what the financial reality is, because there's that vagueness, or there's that
Yeah.
not following the standard that can create all those questions.
I'm wondering, can you share an example, Brad, of a matter where, divorce, obviously, where, involved a business owner or executive where the business issues became just as important as the personal issues?
For sure, and that's pretty common actually, because if a business is one can effectively become one party's life. It's their passion project,
Yeah.
a central asset that they put their blood, sweat, and tears into, especially if they're a founder. the value of business, the structure of the ownership, and the client's continued role are all directly at issue. So the challenge in those kind of cases I've found is not just determining value, although that's important. It was structuring a resolution that allowed the business to continue to operate without disrupting operations and still achieving a fair outcome. And that sounds simple, but it isn't always. And then the required coordination beyond a typical divorce framework of, as we mentioned, working with financial professionals, understanding the internal dynamics of the business, and negotiating solutions. And that will also frequently involve, if it's if the owner, the person getting divorced, has a really good business staff or operation crew, they're also frequently a part of the litigation. They don't generally love it, but they tend to be
Oh,
helpful in getting that resolved and getting the information.
I want to ask you one last thing here before we wrap up. And, and it's that, what is it in your experience, in these high stakes cases that might distinguish a case that, sort of stays strategically controlled versus a case that gets, financially or operationally disruptive?
Well, it's taken a long time to learn this, and it seems counterintuitive, but cases that stay controlled tend to have a lot of early effort and evaluation. So the clear understanding of the risks, the objectives, a good flow of information in the terms of getting the documents. And like I said, getting the cards on the table, targeted discovery, use of experts pretty quickly to develop the case, because the longer things go, it's just going to impact the business worse, and it's going to wear on everybody. So once a disruption starts, it can kind of build on itself, affect operations, relationships, and ultimately value. So strategic control is not just about winning the litigation, although that's important. It's protecting this larger system by getting the work done and proceeding with your plan quickly.
Well, we are, as happens, out of time, Brad. But as always, thank you for connecting over this and sharing your expertise. I really appreciate it, and I look forward to talking in the future.
Yeah, me too. Thank you, Sean.
That's it for today's episode of Family Law War Room with Brad LaMorgese. To learn more about Brad and his work in complex family law matters, visit his website, lamorgesefamilylaw.com. As always, thanks for listening, and do us a favor, subscribe, share a link with a friend or colleague, and maybe even leave a review. We'd appreciate that. It helps others find the information. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.